Hello, this is Professor June McLaughlin. I am providing you with a short lecture, only has 15 minutes on this program, a short lecture on Chapter 18, which has to do with contracts in writing and the Statute of Frauds, as well as the Parol Evidence rule. I'm using the slides from Chapter 18, and I'm going to skip these initial ones, although these case hypotheticals are really interesting. We don't really have time to go through it. The Statute of Frauds is a very old English statute that we've incorporated into U.S. contract law. And essentially what it does is spell out which contracts are most likely to be subject to fraud, and then require those contracts by law to be in writing in order to be enforceable. So Chapter 13 and 14 talked a lot about contracts and how to make them valid. A valid contract has an agreement, has offer and acceptance. It has consideration, that bargained for exchange of promises. It has a legal subject matter, and both parties have legal capacity. And when you ask if a contract is valid, you look at those things. And then I want you to imagine yourself for these chapters, and in this section in general, imagine yourself as the court. So previously when we were in tort law, maybe we identified with a plaintiff or felt particularly like a lawyer who was representing somebody. But for contracts in the Uniform Commercial Code, I want you to come from the perspective of the court and answer each of the questions the court has to answer for itself before it addresses what the parties want. So the parties want the contract enforced. This is, we got to do it. That person's in breach of contract. I need compensation for the breach of that contract. But before you get there, ask, is it a valid contract? And that's really what Chapter 13 and 14 are all about. And then you're going to look at things like enforceability. And enforceability has to do with, did it take the proper form? F-O-R-M. Form, not meaning like a form you fill out, not like a DMV form or a form you have to fill out at admissions and records at IVC, but this is the proper form of the contract, the proper construction. Did it come in the way that the law required it? And if it did, is it valid? And if it is it enforceable? So we want to, and enforceability has to do with form. And for Chapter 18, enforceability has to do with, what does the Statute of Frauds say? What does the Uniform Commercial Code say? And then other enforceability concepts like the Parol Evidence rule. Okay. So the purpose of the Statute of Frauds is to give everybody a heads up about what's required in order to have an enforceable contract. It also keeps out of trial and a hearing any unreliable oral testimony. And so frequently students are like, well, if I have an oral contract, and it was just the two of us and nobody else was a witness, what does the court listen to? Even if you're a business person, let's say it was all done in person, shake of hands, my word is my bond type of stuff. The court listens to oral testimony with contracts that are required to be in writing that are governed by the Statute of Frauds. Unreliable oral testimony is excluded if the contract was not in writing, and in general excluded except for certain situations under the Parol Evidence rule. So final purpose of the Statute of Frauds is to, it is for the welfare of parties to prevent them from getting into contracts which they don't agree with. So what kind of contracts are subject to the statute of frauds? We won't cover all of them. We'll cover some of the big ones. Contracts not performable within 1 year from the date of their creation. Promises in consideration of marriage, which are prenuptial agreements, and to be honest, any marriage and marriage-related agreement needs to be in writing. Contracts to pay for the debt of another, that's a surety contracts. Contracts that govern real estate, and contracts for the sale of goods valued at $500 or more. All right, sorry, let me go back. I'm going to go back to 7 and kind of hit those quickly one by one. So contracts not performable in 1 year. A great example of this is you've been hired, you have a consulting agreement, and your consultancy will last for 18 months. And you must consult this business for 18 months, and that's the term of the contract. That contract cannot be performed within 12 months because you've been hired as a consultant for 18 months. And there may be provisions in that contract that allow for early termination for whatever reason, but still the original contract for 18 months is not performable within 1 year from the date of their making. Marriage contracts, for obvious reasons, partly because, particularly because the state gets involved once you have, it changes your legal status, and then benefits flow to you that would not flow to you otherwise. So those contracts need to be in writing. It can't be, well, he said we were married. It's got to be a marriage contract. Surety contracts. So this comes from a lot of case law where people promise for whatever reason to pay for someone else's debt. An uncle promises to pay for a child's schooling or a niece or nephew's schooling. And that kind of promise needs to be in writing, particularly if it's some kind of long-term agreement to pay the debt of another. The law requires that in writing. Real estate contracts must be in writing, and that's not just mortgage agreements. That's really a financing contract. This is the actual contract for the transfer of the property, physical, real property from one party to another. And then contracts for the sale of goods valued at $500 or more. And this is a contract that's governed by the Uniform Commercial Code. Typically $500 or less, the law is going to be less suspect of fraud. When the dollar figure goes up, then we want the assurance of a contractual agreement that is in writing. What are the writing requirements? Now we know what needs to be in writing. What are the requirements? You need, under the common law, which is case law, to have the clear identification of parties to the contract, what the consideration given was, the significant terms of the contract. It must be signed. What's the purpose of the agreement, the subject matter of the agreement. And then I want you to look down at the slide. The requirements under the Uniform Commercial Code, there's 2. That's a big difference. So under the common law, you have multiple things that must be identified in the contract. Under the Uniform Commercial Code, which governs contracts for the sale of goods, you only need to identify the quantity of the goods and have a signature of the defendant. So this will explain for any of you who know how businesses are invoiced or transactions for the sale of goods, and we'll cover this in more detail in Chapter 21. But it's a reduced requirement. So I want you to notice that the requirements are less stringent. You don't need to have the significant terms identified. You only need a signature of the defendant. You don't need to know the parties to the contract, so it's a much lesser standard. And we'll get into that a little bit more in Chapter 21, why that is. And I'll just say here briefly, mostly it's because these are merchants and they know what they're doing and they make contracts a lot. So the law doesn't require them to have as many details. So there are exceptions to the statute of frauds. One is if someone says, yeah, there was a contract, an admission. Yeah, there was a contract. Okay, well, yeah, but it's not in writing, but yes, there was a contract, I admit. Or partial performance. So if the court can see that people were functioning as if they were in the contract, widgets were getting manufactured and delivered, payments were being made, but no contract was in writing, that will be an exception to the statute of frauds writing requirement, and parties will be estopped, that promissory estoppel. Parties will be prevented from denying that a contract exists. My time is running out, so I'm going quickly. So the parole evidence rule, interesting. When is oral testimony that lends to written contracts, that talks about the written contract, when is that allowed? Never, because the parties should write their contracts out, except when. So slide 12 talks about when you might be allowed to introduce parole evidence, which is just oral evidence. It's just another way of saying oral evidence. And you can take a look at those if there were ambiguous terms, if it was incomplete. Oral testimony is allowed to help the court understand what the parties' agreement was. If everything is in the contract, the parties can't deny what's in the contract by trying to admit oral testimony contrary to what was written. Instead, it will help the court. So parole evidence is allowed to help make contracts clearer. And as I said kind of earlier, if the contract is clear, it's integrated, everybody knows what the terms are, the price, the quantity, it's signed. If it's got everything in there, it's a completely integrated contract and no parole evidence will be allowed. But if it was ambiguous and really did not appear to be the complete expression of the parties' agreement, then parole evidence may be allowed. So that was my drive-by lecture on Chapter 18. I hope you guys are doing well, and I hope you find this lecture useful, and I will try and upload it now.